Good afternoon and Happy New Year, everybody. This is the City Council closed session of Tuesday, January 16th, 2024. I now call the meeting to order. Madam Clerk, will you please do the roll call?
Thank you, Mr. Mayor. All council is present except for council members Gameros, Marr, and Harper.
Good. Okay, public comments are going to be heard at this time. Each member of the public will have 3 minutes to speak. Members of the public in the chambers will speak first, and then if there's anyone on Zoom, we'll hear from them. So we have people here that would like to speak. So I welcome you to the podium, and Mike's ready for you. You get three minutes.
Hello, good afternoon. My name is Dennis D'Alessio, and I'm with the manager of D'Alessio Investments. And we're speaking on behalf of Wallace, the Wallace issue that's coming up. This property was a homeless shelter before we purchased it, and we purchased it as is. When we purchased the property, we didn't add any kitchens, we didn't add any bathrooms or bedrooms or any units whatsoever. And the appellate court judge has opined on that and agreed with us. And now it's a statement of fact. The tenants at the property were brought in by the OC Housing Authority, and the OC Housing Authority inspected the property every year and every unit every year. The fact is, the shelter, through its years, had a number of accommodations provided by the city. A few of those things are in that packet I sent you. But one, namely, they were allowed to build a 4-unit apartment that allowed for 8 kitchens. Somewhere along the line, those kitchens were, partition walls were put in, dividing those kitchens up. Subsequently, the shelter wanted to add offices, and they maintained their unit density by saying in the plans, 2 kitchens, 2 units, all the way through the process. In 2015, I went to the city and I pulled and applied for as-built drawings, as-built plans for everything on that property. And the plans are right here. I sent them also in the packet. The city is saying that these as-built plans don't exist anymore because they were expired. My comment is, how can as-built plans be expired as they're approved and as-built, as existing? And that's what's in here. All the property was signed off with these job cards on everything that's in the property. In 2019, I received an NOV, notice of violation, for 29 items. I fixed all 29 items. And on the NOV, it said very clearly that if they're not fixed by the date, then there'd be citations. I only received 1 citation the entire time we owned the property, and that citation I appealed and I won, stating that the city lost that citation claim. Long story short, judges listen to city attorneys, and I understand why the judge would believe a receiver is necessary. But the receiver has been on the job now for 3 years. Homeless have moved in, fires have moved in, graffiti's all over the place, and the place has fallen apart because the receiver wants to destroy the 14 units that are there and put in 6 units. There's a problem between the zoning code on that property and the general plan. The general plan allows for 9 units, and the zoning only allows for 6 units. But now with all the new ADU laws and what happened.
3 minutes are up.
Yeah, your 3 minutes are up. I know you didn't get a 1 minute warning, but yeah, we're done with the 3 minutes. So thank you very much.
Mr. Mayor, if it pleasure you and the council, we have Alicia Patterson from Rutan and Tucker on Zoom. Could she go? Because I think she would provide some context to our comments. Is that possible?
Normally what we do is we do people in the
Right.
chambers and then we do her. Does the order?
I think the other speaker, we would ask that you defer to the Zoom speakers, the attorney, that they
Okay,
would.
I mean, it's okay. That's fine. So don't start his time. Can we hear from the lawyer on Zoom?
Sure.
Good evening, City Council. Can you hear me?
Yes, we can.
Thank you so much for accommodating me. My name is Alicia Patterson. I'm with Rutan and Tucker. The property owner, Mr. DeLesio, and his company retained my firm recently to look into some of the state laws and entitlement issues on the property. We've also joined his current attorney as counsel of record in the litigation. So just to take a quick step backward, this property, 1963 Wallace, has been subject to a receivership action for, I think, over 4 years now. It was filed in February of 2020. The receiver has had full physical possession of the property since November of 2021. And I think if you look at the letter that we submitted this morning, what you're going to see is we've put before and after photos. It's night and day. The property has significantly deteriorated and is continuing to deteriorate under the receiver's care. Part of the reason for that is that it's been completely vacant since June of 2022. That was when the receiver made the decision to terminate all of the tenancies. Most of the people who were living on site were low income, extremely low income, and very low income families. Most had school-aged children. 3 of the families had children with special needs. All of those tenants have now been forced to leave the property, and the property has been vacant for a year and 9 months. And with that has come all of the problems that come along with having a vacant property. There's squatters, there's nuisance, there's arson. The city has actually written a letter in October of last year to the receiver, apprising him that the condition of the property is not acceptable, and attaching calls for service logs since July of last year that show, or July of 2022, that show all of the different law enforcement services that the city has devoted to this property. And so we're at a critical point in the litigation. We really hope that the council will take a hard look at this case tonight. Mr. DeLesio is looking for a solution. He would like to find a way to get out of the litigation in a way that's going to be a win-win for both him and the city, a way that will retain the existing housing and rehabilitate it. Even though it has fallen into disrepair under the receiver's care, it is absolutely salvageable. I think there's someone here tonight who can speak to that. It can be rehabilitated. It can be continued to offer for housing. Mr. DeLesio has had my firm look into the legal options, entitlement-wise, what different state laws can be used to entitle, or I guess re-entitle, the existing number of units. So I can tell you that there is absolutely a path forward if there's willingness on the council's part to have this property rehabilitated. And we hope you'll take a hard look at this tonight and provide direction to the legal counsel for the city to oppose any proposals to demolish the housing on the property, which is what the receiver is proposing to do, and instead work with Mr. DeLesio on ways to rehabilitate the existing structures.
Thank you. You hit it perfect at exactly 3 minutes. Next speaker. Let's see. Let me make sure your mic's on. Go ahead.
Hi, my name is Steve Cedarquist. I'm a general contractor, an electrical contractor, and also a contractor for HDTV. I walked the property about 2 years ago with some code enforcement officers and some other, I don't know if they were council members, I'm not sure. I didn't see anything wrong. I mean, I look at, Tarek and I look at dilapidated properties every day. I mean, that's what I buy. And we did not see anything on this property that looked like it was in dilapidated condition. The only thing that I saw personally was a handrail. When you go up, the handrail to the second floor was loose, which needed to be repaired and disrepair. And also a couple service doors in the back that were for the water heaters. But everything else looked like it was in a good, normal condition for that age of a property. And so I told Dennis that I said, yeah, we'll, once you get this back, we'll get it cleaned up and pull the necessary permits, whatever needs to be done, and get it back up and operational. I mean, if I was to buy this property, I would do that. I mean, I would, Tarek and I would put $100,000 into it and make it an amazing property and rent it out for a lot of money. That's what we do.
Thanks.
Thank you.
Thank you, Mr. Mayor. I believe there's one more attorney on Zoom, but I'll go right now. Thank you for indulging us. My name is Steve Sheldon, and my address is on the contact information with the city clerk. My company develops residential communities, both market rate and affordable for sale homes that are deed restricted, low income. the owner, who I was under contract with to develop the 440 Fair property, asked me to look into this matter on the Wallace property. And I was shocked with what I saw in the actions of the receiver. But what I noticed most was there was a email from the Assistant City Attorney, Amanda Pope, stating that the only outstanding code enforcement item was the entitlement of the site. I said, So I said to the owner, instead of litigating, let's just re-entitle the site. Use the housing laws recently passed by the legislature, by the governor. We can do a called a Housing Accountability Act and density bonus, and we can get back to where you're at right now in the first place, regardless of whatever numbers are being said. So that was our that was our game plan. I submitted such an application in July of 2023. Immediately received an angry email from the receiver accusing me of undermining his authority and violating a court order. We responded that we just wanted to have a common goal of bringing the property into legal compliance, and can we meet to do that? He's refused all my requests to meet. We recently submitted another request to the staff to meet with them to go over our application, because this is a unique application of existing properties and what needs to be submitted. He forbid them from meeting with us. He then accused me again of violating the court order. I challenged him to go in front of a judge and seek sanctions against the owner and myself if he felt that we did, because we're going to do it some more. And of course, he wouldn't do that because he knows he's wrong and he's a bully. So, in fact, he doesn't even want you to listen to me today or for me to be able to talk to you. He told the staff not to talk to me. He told the city not to talk to me, which means the city council also, if you take it to the right context. If you sit back and look at what he's done, he took control of the property and violated the due process of the owner. He then evicted low-income, long-term residents, which our housing element is against. He then tried to financially bleed the owner for 2 years, bleed him out financially so that he couldn't fight, in an effort while he puts the property into disarray so that he can have the property demolished. It's really wrong what's going on. I recommend, personally, is that you allow us to meet with the staff. We come up with a plan, you go back to the court, you get them to certify it, we will implement it, and then when we're done, it looks great, you fire the receiver. Thank you.
Thank you. Do we have another person on Zoom, Madam Clerk? Yes. Okay, you have the floor.
All right, can you hear me?
We can, yes, thank you.
All right, thank you. Good evening, Mr. Mayor and City Council. My name is Grant Hermes. I am a licensed attorney, and I'm here talking about matter number 2, specifically 440 and 1779. While I'm not the current attorney of record on the case, I have been in the past, so I'm familiar with the issues. Mr. DeLessio asked me to speak tonight so that I can advise the council and comment on the pending litigation. The issue is, I'm not aware if the council knows that the city is continuing to spend countless resources prosecuting this litigation against Mr. DeLessio and DeLessio Investments, even though, one, they no longer own the properties. They no longer own 440. They no longer own 1779. My understanding is they were sold in August of 2023. So I don't understand why this litigation is still pending against them. It's still being prosecuted against them. 2, the tenant who initially disguised itself as a church, who was allegedly operating the unlicensed marijuana business, was evicted years ago. 3, in an effort to work with the city and remedy any issues the city had, Mr. DeLessio evicted all of the massage tenants at the property within days of receiving any notice from the city. These properties have been a target of code enforcement for many years. I saw it firsthand as being Mr. DeLessio's attorney, and it led the city to file this instant action in November of 2020. The complaint sought a temporary restraining order, and it seeks injunctions, nuisance claims, and a receiver, just like with the Wallace property, a receiver to be appointed over both of these properties to take control given the alleged severity of the issues at the property. By way of history, the city went in ex parte when it first filed the lawsuit to try to get a TRO, and that was denied. The city went in again for a renewed TRO. That was denied. A few months later, in February of 2021, the court did issue a preliminary injunction that no unlicensed marijuana dispensaries were to operate at the property. We all agree that that was appropriate and we never contested it. However, no injunction was ever issued as to the original request or as to any of the massage businesses. Fast forward 3 years, I do not understand why the city continues to prosecute this case. Mr. D'Alessio no longer owns the property. It appeared to me that the city was only keeping this case active over the years to see if any evidence came up. It didn't. It's now 3 years later, and if something were to be present, I would imagine that the city would have brought that to the court's attention immediately. Throughout the entire process, Mr. D'Alessio remains from day one. He's tried to work with the city, address any of its issues, and it's attempted numerous times to engage in settlement discussions to resolve these matters. And I hope my comments tonight, the city, the council, and the mayor consider, and I hope that a resolution can be resolved with this specific.
Thanks. Your time is up.
No further speakers, Mr. Mayor.
Madam Clerk, would you please read the titles?
Thank you. Item 1, conference with label negotiators pursuant to California Government Code Section 54957.6A. Agency designated representative Lorianne Farrell Harrison, city manager, and Alma Reyes, deputy city manager. Name of employee organization is Costa Mesa Firefighters Association. The following 3 items are all conference with legal counsel regarding existing litigation for 3 cases. All of them are pursuant to California Government Code Section 54956.9D1. First is City of Costa Mesa, People of the State of California versus D'Alessio Investments, 440 Fair Drive and 1779 Newport Boulevard, Orange County Superior Court case. Item 3 is D'Alessio Investments versus City of Costa Mesa, Orange County Superior Court case. Item number 4, City of Costa Mesa versus D'Alessio, 1963 at Wallace Avenue, Orange County Superior Court. Thank you.
Okay, thank you. The city council will now recess to the community room for our closed session meeting.